Friends, today I am going to discuss Constitutional Law of India Part 2 under Semester 2. What is Doctrine of Eclipse? Let us start. The Doctrine of Eclipse is rooted in Article 13(1)(3) of the Indian Constitution, which deals with laws that are inconsistent with or violate the fundamental rights and enshrined in Part 3 of the Constitution. The essence of this doctrine is that a law that is inconsistent with fundamental rights is not entirely nullified but becomes temporarily unenforceable or eclipsed by the fundamental rights. The law continues to exist. That is, such a law does not become void ab initio from the outset, but it is suspended and remains inoperative as long as the conflict with fundamental rights persists. That is not resolved. The doctrine of eclipse applies primarily to pre-constitutional laws, those laws that existed before the enactment of the Constitution. Now, Article 13(1) is applied to laws that are inconsistent with fundamental rights after the Constitution came into force. There is a leading case in this case, Doctrine of Eclipse, Bhikaji Narayan Thakras versus State of Madhya Pradesh, 1955. This is a landmark Indian Supreme Court case that established the Doctrine of Eclipse, holding that pre-constitutional laws inconsistent with fundamental rights are not void but merely inoperative, eclipsed, and can become valid again if constitutional amendments remove the inconsistency, as happened with the CP and Berar Motor Vehicles Act 1947 after the First Amendment. The CP and Berar Motor Vehicles Amendment Act 1947 gave the state power over transport routes. Petitioners argued the act violated fundamental rights under Articles 19(1)(g) and Article 31. Under the newly formed Indian Constitution, the Supreme Court upheld the act's validity, stating it has become inoperative due to Article 13(1) but has not been restored. The court clarified that the first constitutional amendment 1951 removed the conflict with Article 19(1)(g), making the 1947 Act fully enforceable again, demonstrating laws can be revived without reenactment. Now I am coming to what is doctrine of severability. In contrast to the doctrine of eclipse, the doctrine of severability applies to laws that are found to be partially unconstitutional. Under this doctrine, if a law contains provisions that are inconsistent with the Constitution, the unconstitutional part can be severed or removed, while the remaining valid parts of the law continue to remain effective and enforceable. The important element in this doctrine is that only the unconstitutional parts of the law are nullified, while the rest of the law remains intact and operational. Now, there is also a leading case, the State of Bombay versus RMD Chamar Babuwala, 1957. The respondent, Chamar Babuwala, ran RMDC Crosswords, a prize competition advertised and printed in Bangalore, Mysore, but circulated in Bombay. The Bombay legislature amended its 1948 to include competitions run from outside the state, levying a tax on organizers for amounts collected from Bombay residents. Now, Chamar Bagwala challenged the tax, arguing the state lacked jurisdiction, no territorial nexus, and that price competition were trade-commerce protected under the Indian Constitution under Article 19(1)(g) and 301. Supreme Court gave the decision that there was sufficient nexus. Yes, substantial activity occurred in Bombay, creating a valid territorial link. The court found these were gambling, not protected trade, making them subject to state regulation and taxation. Bombay's act was a valid exercise of power to tax gambling, and the taxing provision was constitutional. From this, it is clear that gambling activities are outside the scope of fundamental rights related to trade and commerce under the Indian Constitution. So, thanks for watching this video, friends. This is all about the doctrine of eclipse and the doctrine of doctrine of severability. Thanks for watching this video.